I know, sir, before you joined the AG's department, no, now said in that case now started at our court, and
yes, said in the case, no, I shall say 2019.
2019.
Yes, at the time, January 2019.
Okay.
At the time, Madam Grakufuna,
Attorney General.
In 2021 June.
Yes.
And
I obey.
And if you have a better
case, no, say our court. Yes. Oh, okay. But unim the history of that case.
Yes, minia. Minimpa.
Saying
yo say share the case history send Americans see no case no say 2019 and now on mine no through the Attorney General the charges ebo nipa mienu said na any Daniel
yes
na say no mudi asem no fra dance here until 2021 ya na edus at the PW7 somewhere June, July, and Madam said Nakase
Otukwan.
Into here meaning say for almost 5 or 6 or the witnesses now were part of the proceedings.
Okay.
Yeah, the lawyers now were part of the proceedings. Into here after June 2021 court July 2022 kwan call you know. And now 1 month the court no etwa over 16 months. That's 1 year 4 months. Na court to just obeba.
In the court they put the case no on hold.
Those were the times na your court maybe obeba or ma then you have to go to the process say you're trying in absentia court no take time and make that order no some make order say yen 7 because baby obia by substituted service
yes
enti the lawyer copy of it the be call be any fear be not the sign publish your high court and then daily do a graphic for 21 days so after 21 days, and finally, who say there, it me at was. Until thereafter, no, and a prosecution, no, a closing the case, and according to the submission of no case, say, we make application, and according to rules, there was a case to answer by both parties. By that time, no, not said that lawyer crown in the case will be now on my court.
Oh, okay.
In terms of that, no, court, no, according to say 2024 April, court say there, you did assembly we, inti, court we do assembly.
In the after, sir, or mumu closing mu case, no. Said lawyers na file application for no case no court ne ka said no they have a case to answer.
In fact, said the lawyers and file application.
File application.
The 7th witness that was the time said the one maybe
okay.
Okay. So now the case no in their absence. The other party at Daniel.
Daniel Azim.
Yes. So you close the case no. I mean you know as a lawyer.
Yeah.
But court evaluated we say case.
Case to answer. Okay, and the court rules say they should open their defense.
Exactly. And Daniel, a shas, or Kasaye, a friend and dance here. If you said the answer, no,
not only her.
The court will close the case. No.
Oh, okay. And set the number by virtue of the fact that only Hano on one open the defense.
Debbie.
In the against her, no. The court need basing the decisions on what the prosecution put before the court.
Yes,
but that's against said the number.
In fact, Judge what she did, they say, or she had dance here, prosecutor said, Diaba.
Yes.
You know, some cross examination has said the lawyers.
Yeah. Before so be too quiet.
You know, some said the statement of the police. Yeah, you did a tender, the caution statement, the charge statement.
Okay.
To she I will make a determination.
But now that you've given us this background, you know, the Court of Appeals said in their respectful opinion, no, 78 charges now, more they ebo one, no. Some of them were incurably defective. Oya hoshia enyeye. In their judgment, no, omu boy no nyina tugui, and they focused on bare 5. We will come to the 5, but that the whole AG's department, where the quality of prosecutors are more hono, to draft charges are that many defective, no, and yeah, indictment on Munyana.
I mean, yeah, Manya Quine already for P judgment.
Yes.
Now, the American can say, oh, per se judgment and court for P. Mayano. Say, whether say, yes, son or seba, and I say, yes, son or seba. I was a 1. Unya high court judgment.
Okay.
Okay. 2. Unya the record of appeal or record of proceedings. Let me read that record of appeal. Unya enubi kind.
Yes.
3. The exhibits are a dancia in Kratasema. You did a dancia. So unya be, and more importantly, the forensic audit report.
Okay.
Of the auditors.
Okay.
And name was only being kind, and so kind of appeal quantity, and I'm sure not a deceive think and say, Sana, I was a echo.
But San Yomanina were part of the record of appeal before the court
exactly.
of appeal. If appeal is by way of rehearing, I mean, he said the justices no share San Yoma way.
Yes, that is the presumption.
Okay.
But some persons who say what I judge is on me right and on me wronger. So we are no kind. They can make a better assessment because people more comment so judgment no say I can't say that here. But unya the original record, yeah, or for more than and kind muya because Obi, I mean as a lawyer, know High Court in my judgment. Court of appeal me a firm judgment. Supreme Court so the fact say judge is straight court of appeal my judge doesn't mean say don't kind of final.
Sure.
So as a share side alongside it. In terms of the charges, my charge sheet no more. At least from count 1 to count 80 by 78.
Yes, 78.
Meaning, I am a dense meet me who baby, judge bet me a cast charges no a be a defective. So share every charger.
Yes.
And maybe an name you know. Statement of offense and a particulars of the offense.
Sure.
Statement and yes, we are there, according to section 124 as a statement.
Yes.
A particulars and also no a bet you say on this day Kofi Manu uko we are Kwabramwa Nempabwa ni boye 2 cities.
2 cities.
Yeah, not any odia.
Yes.
That's it. A little brief
about
about
the element of the offense
exactly,
of stealing.
Exactly. Say o share charge sheet prosecutor say prepare na because each one of them no enough information. Yeah, was say accused person dey be say want me say oh there be ya dey ma me no mahu dey ntia na dey na be gina court. Na say o share analysis omo ye na judge say part say oh and nam say I think count 34 on the financial loss to the state, all the counts of financial loss to the state. So mo gidi say small portions go am memunti no enye enough.
Yes.
But o share the Thompson case omo refer na Thompson case no emra ye charge the back court no and a raise objection and a coin could do Supreme Court.
Yes.
Na court no case charges bi o ho amanya den e defective. Don't want some for.
Yes.
Ye ni asem osa case no mo ya monkro ba we de ye bonkro ema empo assuming say nka e a defective ya more better details in the
trial
the trial so case a defective charge o the can assemble this time rather and intina so share yemre mu a maka section 31 of the Courts Act.
Yes.
E ka say o court ka say a defective the court nyawa court nyawo we say ye di asem na wie ama say if you impose a charge no kwa say defective a better when you the full information.
Yes.
So say dance here e wo court create an so a charge kwa a defective wa still ano court ka say there be sadanse on kwa dia court nyina so emu of
but he thinks on the woefully causing financial loss to the state, it could have been put in a way like this. Kwame Diewu, on or about 1st April 2026, while serving as finance director of ABC agency, woefully authorized the payment of 1.2 million to XYZ Limited for goods which he knew had not been supplied, thereby causing financial loss of 1.2 million to the state. This is more like it.
The rendition make us any wrong.
Okay.
Why expanding?
Okay.
The ages of science no expanding say. But what is the difference? Difference and say nipa na degna course say di na asem no.
Yes.
Adanse biaba. Ya actually say nti na de ba court na. Enti bia na ya fa na dwuma ya ma. Ebia fa goose na ma but ye bonkru no because so now you're managing director.
Yes.
Goose na koto ye. So far as you lead evidence to let you know say are they going to do in court no. I mean unless you want to be so technical and that's what the law wants to avoid by giving us section 31(1) because you see you strike us out all those charges no meaning say on the merits no you need asem no. These are close to almost 70 million 60 million e was charges no more meaning say nam sad we say no are we saying this can no ayra properly speaking, what we say let's do a retrial on those counts because I don't know you need it.
Yes. Baba Unimun so say even in civil trials where the standard no any as high as criminal, we know the things Order 81 can cure. Constitutional breaches count even for civil trials. in the if say a criminal trial where the liberties of the person is at stake, constitutional breaches should at no point and under no circumstance be countenanced.
In British constitution, from what I explained.
Yeah, until the court thing say you did.
Yes, you look at 19.2d. It talks about the nature of the offense. It does not talk about the particulars of the offense.
But you don't think that the spirit behind that provision, no? Nature now you one is just for you to let the accused person know what you are charging them about.
It is true.
Yes.
But you can't nature the way now it has say you are not going to give the person all the evidence. But only a rough idea.
Okay.
Say and then we can't win a CBA where we are. You more kind of number.
Okay.
Kufika na where we are. But you we are can how ni winning an embedded. So the rationale behind that provision is say the accused person have some rough knowledge about the entire say rough knowledge you can say onsa enkaya untna se
Asempa FM
expanded the young farmer.
Yes.
Now eventually can say what's here, but that's why the provision that one no. I'll leave that one to the ages of appeal. But that's a serious matter.
That's fine.
To look at.
And the other thing I'm facing with Busani said during the trial at our high court, no, was there a point defense lawyers no raised the issue of defective charges?
No.
Throughout the high court proceeding. Oman raised baby.
No. Because someone raised there have been a ruling on it. And that will make say like this Hanan matter.
Yeah.
Someone raised the issue.
Yeah.
There's a ruling. Once you say you go up.
You go up.
And the storms in there was an objection. Then you go up. Nothing.
In the certain Tamaklu, no man raised the issue of defective way.
No.
But as practitioners, we know, sir, if indeed, say the Court of Appeal, if they believe, say, a constitutional breach, whether you raised it or not, didn't matter.
Exactly.
Yes.
So now, with this Court of Appeal decision on this defective charge, you're right.
Yes.
We affirm that way now.
Yes.
What it means is a small technical defect the charge sheet, So what we are going to seek in our crown now to make a court in jail. So many says, I'm a state prosecutor. Now, a small mistake. Yeah, on substance like
Asempa FM.
Yes.
So yeah, support to this Court of Appeal decision on this charge. With meaning say nipa no. That's small. For example, tuya yeboa, where we are muskali din, kofi ajapade.
Yes.
That way, make us say so enough. Me was my we are there no. You be any say o me ho. Be kwa na ba jatu say we are. Na fi my appeal say we no. A defective entry court in Nyanya. How absurd would that position be? And this Article 92D, no, it's been wrongly applied by the Court of Appeal.
By the Court of Appeal.
Yeah, caught by that, I assure you. A lot of people in prison now almost started filing appeals.
They would all
most of them will come out.
Acquitted and discharged means on all those specific charges, no, the state cannot bring her back.
Exactly.
On those charges. Say be a different investigation because who be before but on these specific charges, 500,000 about tampa de no card 50,000 and a driver could buy and all the other two ne kahona court they can say okay whether the charges were correct but I want to me improve beyond reasonable doubt and no it's done. Yeah. The state cannot go back again.
That's why the question we keep asking the question. Scano ewohi.
If it establishes Sika Biayra. For now, according to the Court of Appeal, Sika Biayra.
Court of Appeal say Sika Aira. Sika Aira ni nya dance baby skinny pana scano e
yes.
In the Court of Appeal, obviously, wrong. Anytime this Attorney General, because the AG's office may respect it. Attorney no more no. Omu ye adwuma pa. Omu take omu time. Ye adwuma. Yo, Mr. Stella no mo ye. So that's why so the Attorney General say OTA the officers somebody say SAEP.
Yes.
Because so far Court of Appeal the inquiry on the face of it and that case no unimu you will begin to jubilate. Because you say it's a dandy name so kwase no a dance here na we say hey na here den that is it. I mean my other friends some guys Tia say they are more of prosecution lawyer than defense lawyer. We a defense lawyer. I mean, I've been a defense lawyer all this while. You may be happy.
Yes.
Because it's something that you use, ammunition that you use to defend your clients.
Yes.
But if you're a prosecuting attorney, you must be worried. And so now, fortunately, I'm the prosecutor. So I've seen two sides. A Juma or Moyo. Evidence, Munia Obi. And a war. Copious. And I'm going to say a mountain of evidence.
After say Court of Appeal judgment, when you read comments, more as prosecutors, more a shoddy job How do you feel about that?
Yeah, na me tiana assignment select kakra. Empu do be no mo de gofredame na yes oyewi. Me wa gofredame was not that Attorney General. Emra case.
Emra case ne started.
Yes. Oh, by 2021, that time when almost case na, but let's take that one aside. Ajuma prosecutors yes omo very good job. Rather than the Court of Appeal and I adwuma ye. Sana me hu no. I stand by this.
For all the 3 judges to speak in unison, no.
You see, it doesn't matter. Makacho. There be instances at High Court and my judgment.
It's possible, say Court of Appeal Supreme Court can pass. Yeah, Court of Appeal the initial.
And na me share judgment na Court of Appeal etro ye na. Enti me point emrani bi no. Evidence Act on refer section 175 for no. Enye adwuma. Section 60 on ka ho asem say ento magina aye we no. Enye adwuma. Because our exhibit a document was my receipt no. A valid one. So adwuma na process aye ho no. Any investigators media omo ye adwuma pa. You co investigators. We share the kind of investigation question from Bison Monsem, a quiet say, statement from some of them.
Yes.
I remember say, oh, statements about hearsay statements. So we had a judgment now.
Yes.
The you could forge if you some of the officers, then we say no.
Yes.
But was there an objection?
No.
So, lawyer be with me. We are objecting. What does it mean? It's on record.
Yeah, but when a hearsay evidence, do you need an objection before a judge sitting on the case can decide say no hearsay evidence way there or admit it? The judge can so
yeah, the judge sitting on the case may want to say we are objecting but mention no but this but this is not the case here.
But the High Court judge admitted it.
And in any case any hearsay who can say it's a first hand hearsay. Nipa dan kamene, for example, me defense counselor.
Yes,
me defense counsel now. Kamekwe zami yoka se obiwa. Obi, that's the prosecutors. This statement amusi mo je free Kofi Manu ho no. Manye free Kofi Manu ho. I'll deny it. What does it mean? It means that you must call Kofi Manu.
Yes.
Otherwise, it's on record. That's how that's how it works. So, you must look at the various things I want to isolate them. Then punch on them. There's a case that maybe I may want you can John Kobina and the Republic. I'm yes, case at the Supreme Court. A similar instance where they did auditing. When I made defense counsel, me can say no documents you are moka in free that office now. Moka sem kunya no. Sadia moka nya free. But you know what the Court of Appeal told me? Say no. There's an audit, and by that audit, they've gone through the processes, and so we can also go and bring. Us pushing say they must bring all the documents. What's the reason for the audit?
Of the audit.
Just to say a door
the presumption of regularity no favor auditors.
Exactly.
And you have to rebut.
Exactly.
If you feel say
papa. So that particular case at the Supreme Court, they confirmed the conviction of my client and says notwithstanding whether making auditors on way you must accept it because that is what is being done because auditing is like listen to both sides. And they will come out with a report. Then you must punch holes. But because you go and call all of them. ABI, for example, Asempa, there's an issue here. I feel much you be. I feel investigators by no money 100. You're my winning and a compile report. On back quarter, per this judgment, the court because David report you're more 100 in a moment. But it depend on the defense counsel because there be only Kofi Ankasa or Joy. Only Kwaku Ankasa or Joy. Only Kwame Ankasa or Joy. Then in that case, we must call those names because or Kasa the Oya and I don't put automatic.
And for now, the only way out now is to wait for what the Supreme Court will say. So that is if the AG appeal here. AG
has appealed, but who notice of appeal?
Okay.
Yeah, attorneys na file.
Okay.
I will advise the AG say, my attorneys no, quite no more share dance anymore.
Okay.
Because they conducted the case, they know the kinds of things are a walk way no more. Say, Basse, they can come up with a conclusion on the matter.
Okay.
At the end of the day, I mean, as a lawyer, defense counsel, the main accused person, the gyno.
Okay.
Now I'm a defense counsel.
Okay.
Previously, I was a prosecuting counsel.
Okay.
So every defense counsel will want his client to be appealed and discharged.
Okay.
But this Court of Appeal judgment, you are shining this light.
Okay.
It's going to haunt us in the future because every lawyer want to look at this judgment and say, I'm going to apply it to all other cases at the court below, and then it will be chaos.